The ATF and Joe Biden has been making a lot of news with their so-called ghost gun regulations dealing with frames and receivers, and they're all boastful about this in their end-of-the-year gun control propaganda discussions. But there's a major mistake that the anti-gunners have made in their federal regulatory definitions and language that they just used that's going to destroy their argument when it comes to trying to ban AR-15s in the United States. Stay tuned. I'll point out how the Biden administration and the ATF just gave us the gift of a lifetime. Hey folks, I'm Mark Smith, host of the Four Boxes Downer, constitutional attorney, member of the United States Supreme Court Bar, proud American gun owner, and New York Times bestselling author. If you have not subscribed to the Four Boxes Downer Second Amendment channel, please do so. We're trying really hard to try to get to over 100,000 subscribers to help us with the social media algorithms. All right, folks, very important news. For the last several days, we've been talking about the ATF's open letter dealing with their so-called 2022 ghost gun regulations, which is a propaganda term, of course, but specifically dealing with the frame and receiver definition, where they try to expand the scope of ATF authority in violation of the Gun Control Act of 1968. We've talked about why this is unlikely to succeed for a whole host of reasons, but I don't want to talk about that in this video. I have even better news than the fact that I think that the anti-gunners are going to fail with their ghost gun efforts. The better news is this, that if you read the regulations, and I'll put a link to these down below, if you read the final regulations involving the frame and receiver rules that were promulgated this year by the ATF, the anti-gun community in the Biden administration has made a terrible strategic mistake. They have made a major unforced error that if I were on their team, meaning the anti-gun side that doesn't want Americans to have guns, I would not have allowed this to have been made. But good for us, they've made the mistake. Exactly what is this? You see, I've actually read through the hundreds of pages of the frame and receiver regulations. And I'm going to read something critically important to you. Wonderful news. And then I'm going to point out to you why this is devastating to the anti-gunners and their agenda in the United States. If you read their regulation right at the top, first page basically, I'm looking at it right here. Guess what? Final rule. This is what the ATF writes. In the past few years, some courts have treated the regulatory definition of firearm frame or receiver as inflexible when applied to the lower portion of, listen carefully, folks, listen carefully, the lower portion of the AR-15 type rifle, one of the most popular firearms in the United States. Period. Close quote. Did you hear what I just said? This is not what I said. I am reading verbatim from the ATF's final rulemaking authority, their final rule involving ghost gun / frames and receivers. And they are admitting in a federal document that courts across America can literally take as the gospel. It's a government document. Judicial notice can be taken of what? Quote, the AR-15 type rifle, one of the most popular firearms in the United States. They have admitted what we all know, that the AR-15 type rifle is one of the most popular firearms in the United States. Now, this is devastating to the anti-gunners in America because one of the major goals of the Biden administration and the anti-gunners in America is to ban so-called assault weapons, which, as you know, is a propaganda term for semiautomatic rifles, such as AR-15 platform firearms, which the ATF has just now admitted is one of the most popular firearms in the United States. And why is this so legally powerful and devastates the anti-gun control movement and wipes out the major part of their agenda, which is to ban these types of firearms? It's because, as you know, if you've been watching this channel for many months, if you've been watching this from the beginning, you know exactly what I'm about to say. If you look at the Supreme Court's decision in Heller, 2008, and the Supreme Court decision in Caetano versus Massachusetts, 2016, what do we know? We know that if a firearm, if any kind of arm for that matter, not just a firearm, but if a firearm is commonly possessed by Americans for lawful purposes, it is protected under the Second Amendment and cannot be banned. Let me repeat. If a firearm is commonly possessed by Americans for lawful purposes, it cannot be banned. Now, there's other ways that a gun cannot be banned as well. But the one thing is for certain, if it's commonly possessed by Americans for lawful purposes, it cannot be banned. And the ATF, the quote-unquote gun gurus of the anti-gun movement, right? The gun intellectuals, the people that know all about guns for the federal government, they have the word firearms in their title, for crying out loud, are admitting in a government document, any final rule, which means it's been vetted by dozens, if not hundreds of politicians and hundreds of activists and hundreds of lawyers and the like, and experts, and they have admitted the critical fact, the single critical fact, and whether or not the anti-gun movement can constitutionally ban AR-15s in America, and they've admitted they cannot, as a matter of federal documentary rulemaking authority. Law. This is the law, as they see it. Now remember, Bruin reaffirms Catano and Heller, and this is very important for any lawyers out there. Do not make this mistake I've talked about on this channel before. Unlike other issues involving the Second Amendment, like sensitive places, which are gun-free zones, age issues involving 18 to 20-year-olds, whether they can have guns, buy guns, etc. Unlike those kinds of issues, when it comes to banning guns, when it comes to attempts by the anti-gun community to ban any type of arm, including but not limited to firearms, including but not limited to AR-15s, semi-automatic rifles, historical analogues do not matter. What do I mean by that? The Supreme Court in Heller and Caetano specifically said that as long as a firearm is commonly used or commonly possessed by Americans today, it is protected. So remember also, in addition to the fact that we have modern firearms that are protected, and firearms as well as non-firearms are protected arms under the Second Amendment, how many stun guns were in America in 2016 that were defined as commonly possessed? How many? If you look at the Alito concurrence, he says there were 200,000 stun guns in the United States in 2016 when Caetano was decided, when the Supreme Court concluded that stun guns were commonly possessed for lawful purposes and thus were protected arms under the Second Amendment and could not be banned by the Commonwealth of Massachusetts. 200,000. Now, the other related point is this. The anti-gunners are trying to argue and redefine common possession by saying that we, the pro-Second Amendment community, don't just have to prove that these firearms are commonly possessed or commonly used, meaning possessed. They're trying to argue that we and the Second Amendment community have to demonstrate that these AR-15 style firearms, these semi-automatic rifles, are commonly used for self-defense purposes, that we have to actually show that they're being used, that people are firing these rounds and using these rifles, so on, so on, so on. Of course, that is not the rule, because in Caetano, as well as Heller, there was no discussion of how many handguns were used in self-defense in Heller, and yet they were defined as protected arms. There's no discussion of how many times stun guns were used in self-defense, and yet they were deemed protected arms under the Second Amendment in Caetano. So again, to the extent the anti-gunners try to say, well, even if an AR-15 style firearm is very popular, which we admit in the regulation, you, the Second Amendment community, have to demonstrate that these are actually used for self-defense. But obviously that's not true, because that was simply not discussed in either Heller or Caetano. And despite not being discussed, meaning the number of times self-defense was actually done with handguns, the Supreme Court still said handguns were protected arms in Heller. And even though there was no discussion of stun guns ever being used in self-defense, in Caetano, the Supreme Court still says 200,000 owned stun guns in America is enough for common possession. So again, bottom line is, this is a huge victory down the road when people rely on this ATF regulation as a government document to establish that AR-15 semi-automatic rifles are one of the most popular rifles in the United States. That should be game over in the attempt to ban these guns down the road. And courts should recognize this and should strike these attempts to ban these guns down. And only time will tell, but I think that's where we're going. Okay, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so. We'll see you again soon at the Four Boxes Diner.